The law that they have been charged under, UAPA, is so draconian. You took more than 2 years to pass an order rejecting bail. Supreme Court and High Courts can grant bail if there is prolonged incarceration. And the protected witnesses are saying, हाँ जी हमें तो pressurize किया.
So this Umar Khalid thing is stuck because of one reason is that there were benches like Bela Trivedi's bench, etc., who were denying the bails.
Yeah, who were denying bail. So basically, Umar Khalid and other people went to the lower courts. When matter is so sensitive, the lower court judges are very afraid. They say कि हम लोग dismiss करेंगे, आप ऊपर जाके देख लेना जो भी करेंगे. तो high court judges देख लेंगे, Supreme Court judges देख लेंगे. So the lower courts obviously did not give them bail, and that's a travesty of justice also in our country.
Correct.
Because independence of lower courts is so bad. Anyway, it goes to the High Courts, High Court of Delhi, and the first. There were 3 other accused who had gotten bail way back in 2021. Devangana Kalita, Asif Iqbal Tanha, and Natasha Narwal. 3 of them together had gotten bail, and the bail judgment was great, because it actually watered down the UAPA and said that it has to apply specifically for terrorist activities. You can't randomly use it. Anyway, that order on UAPA was stayed by the Supreme Court. The bail was still, let it be. They're still out. The other accused, the 9 Muslims, they went to the Delhi High Court, and the Delhi High Court, the first such bail plea was filed in May 2023, and in the next 4-5 months, everybody else also filed their bail pleas, and at that time, Umar Khalid's bail plea was rejected, and he then went to the Supreme Court. Now, when the matter was listed in the Supreme Court, the case was before Justice Aniruddha Bose and Justice Bela Trivedi. Now, the judge who issues the notice, and that is the rule and convention followed by the Supreme Court, the bench that issues the notice has to hear the matter until the end. So Justice Bose's bench was hearing it, which consisted of Justice Trivedi also, and he was supposed to hear it. But what happens is the registry somehow transfers the case before Justice Bela Trivedi's bench. Now, in the Supreme Court and in the High Courts, the lead judge, the presiding judge, has a larger influence over how a case is to be dealt with when compared to his companion judges. So Justice Bela Trivedi was a former Gujarat law secretary in post Godhra, Gujarat under Chief Minister Modi, and was ultra orthodox in the words of her colleagues, and was known to not give bail, right? And that matter being transferred to Justice Bela Trivedi's bench was highly suspicious. The registry does not have that kind of auqat to do something like that on its own. So obviously the Chief Justice would have been consulted. It was on his orders. So it was so Justice Chandrachud was consulted, and he passed that order to transfer the case. And now, before Justice Bela Trivedi, Umar Khalid's lawyers, obviously because they practice every day before the Supreme Court, they knew that they are not going to get justice before that bench, because for whatever reason.
Yeah.
So they sought adjournment, perhaps with what hopes I can't comment, but then they sought adjournments. The state also sought for adjournments, and ultimately Umar Khalid's team asked to withdraw that bail plea and try their luck in the lower courts. So that is what happened in the Supreme Court. In the Delhi High Court, meanwhile, the batch of bail pleas were either being heard, but orders were not being passed, or benches were being changed frequently, which led to the entire bail arguments being reheard all over again from scratch before multiple benches. And that went on and on. There were 4 to 5 benches which actually heard bail arguments from scratch. And ultimately, a month ago, the 4th or the 5th bench passed an order denying all of them bail, including Umar Khalid. So, which itself is, such a travesty, because the bail plea was first filed in May 2023. You took more than 2 years to pass an order rejecting bail, And the Supreme Court itself, in many of its judgments, has said that bail pleas have to be heard within weeks. A
Yeah.
judgment has to be passed within 6 months once the arguments are concluded. But there was one bench in the Delhi High Court which heard both the sides but did not pass its judgment for 9 months.
Holy shit.
Until one of the judges was transferred to some other high court, which led to a
Rehearing and redoing of the whole thing.
Yeah, exactly.
This is so frustrating, man. Like, if you are someone like Umar Khalid or any of these people who are in jail, it must be so frustrating. I can't even imagine.
Absolutely, and the law that they have been charged under, UAPA, is so draconian because even if you read the bail order of the Delhi High Court rejecting them bail, it entirely relies on protected witness statements. पुलिस ने 2-3 लोगों को पकड़ लिया, वो इंसान बोल रहा है हाँ मैं उस मीटिंग में बैठा था जिसमें
That's
उमर
true.
खालिद था एंड उसमें वो लोग प्लान कर रहे थे कि हम लोग 50 लोग को मारेंगे. दूसरा आदमी बोल रहा था 50 नहीं, एटलीस्ट 150 लोगों को मारेंगे. Basis those kind of statements.
And those are all like secret people. Those are like protected witnesses.
Protected witnesses. You can't know who they are. And basis those statements, the court actually said that it's a very serious case, and we believe that they are not innocent, which is basically what they have to say to deny bail. They rejected the bail. Now these statements, Meghnerd, when they go for trial, ultimately, whenever they do, 5 साल 10 साल बाद जब भी trial में जाएगा ये case, within 2 minutes, the case will fall
apart.
Fall apart because these protected witnesses will come before the trial judge, and Umar Khalid's lawyer will cross question them. They'll not be able to justify why they said that. झूठ पकड़ लेंगे and the case is gone. It's over.
Yeah.
And the government knows this.
And
The
also,
Delhi
like, there
police
are like
knows
some
this.
very weird WhatsApp screenshots that were also a part of this whole thing. No, like
Yeah,
they were
just
in some.
because you're part of a WhatsApp group,
Yeah.
तुमने conspiracy कर दिया.
That's why it's a larger conspiracy, because of that WhatsApp group. Yeah.
The interesting part is Natasha Narwal, Devangana Kalita, they were also part of that WhatsApp group. Now, Gulfisha Fatima, who's one of the 9 people still incarcerated, Gulfisha Fatima also said, because they got bail, we should also get bail because we are the accused in the same FIR, and the allegations against me are very similar to those two women. Now, in order to deny bail, the judge who authored that judgment, that bail judgment, Shailendra Kaur, she writes कि you guys created the WhatsApp group, which is very different from being part of that WhatsApp group.
What?
And they use this argument to deny Gulfisha Fatima bail.
Oh my god, that is so. Sorry, but like that's so frustrating to just hear about this. Is just like, क्या ही हो रहा है essentially.
And just imagine when Gulfisha would have read this bail order in her cell, what she must be going through.
Yeah, dude, exactly. That's what I'm thinking. Like, I mean, like, just to see, I would laugh, I guess. Like, after a point, I guess that is the one way to go, which is like, I guess this is what is going to happen to us now.
Because would you cry over this? Would you laugh?
I think they must have lost the will to cry, honestly. Now, I think there must be like, they must be numb, and it's
such a dishonest judgment.
Yeah.
Such a dishonest judgment, holding on to, straws.
Like, even chat is saying they're getting very triggered just hearing about this. I absolutely agree. A few questions, Saurav. How does the court determine if those witnesses are genuine? In case of public speeches, there may not be any video evidences to prove them wrong.
Now, see, the UAPA is a very draconian law in that sense because, one, there are 2 conditions to grant bail under UAPA. Number 1, that the prosecution has to be heard mandatorily, which the court satisfied, of course. They wouldn't give bail without hearing the prosecution. Number 2 is that the court has to be satisfied that they are not guilty. Now, that's a big, requirement because to reach that threshold, the court has to actually conduct a mini trial on its own.
A trial within a trial.
trial within a trial, because the main trial will take place after 10-15 years. So for now, the court has to say in its order that prima facie we think they are not guilty. Now imagine a UAP accused, terrorism accused, and a district court judge, making that kind of a statement in his bail order. It's a big threshold to
It
pass.
is. It is.
So therefore, what the court actually then does is go through the material provided by the prosecution, by the investigating agency, and just take a cursory look and say, "अच्छा इसमें allegations ठीक लग रहा है, सही लग रहा है, there is material," and therefore say कि prima facie we think that the allegations are serious in nature and there is substance to it, and we can't say that they are not guilty. That is the
Right.
threshold they have to reach.
Right.
But a constitutional court is also empowered to grant bail if there is prolonged incarceration. This is a very good judgment that the Supreme Court had passed in the
Right.
Najib case in 2021, right? So the Supreme Court and High Courts can grant bail if there is prolonged incarceration. And in their case, definitely there is prolonged incarceration.
Oh, of course there is. Yeah.
And despite that, the bail judgment says that we considered prolonged incarceration, but it is not a right. Courts are not compelled to give
Abbe.
bail just on the account of prolonged incarceration.
But jurisprudence तो है ना?
Jurisprudence hai. So see, the bail
Also,
in such
bail is a
cases-
right.
No, bail is not a right.
Okay.
Bail in such cases is a discretion that the judges can exercise.
In case of UAPA type situations.
UAPA,
Because
or
the
even
law
heinous
is
crime.
being changed to do that.
Yeah,
Yeah.
heinous crimes also.
Yeah.
Bail is not a right; it is a discretion.
Okay,
Right?
got
so
it.
the judge has to clearly, but that discretion cannot be unguided. There is a jurisprudence, there is a philosophy that courts follow, and that philosophy is that bail, not jail. But in these kind of cases, Umar Khalid's case, and several other cases, the courts operate in a way which says jail, not bail. But
It's the same thing, right? The usual thing is innocent until proven guilty, but because of
Exactly.
UAPA like laws, it is guilty until proven innocent.
Yeah,
So the
but
burden
court
of
can still exercise the discretion because
yeah, and the burden has been shifted on the people who are incarcerated. Basically,
Incarcerated, absolutely.
you have to prove that you are innocent.
that you're not a terrorist.
You're not a terrorist. Yeah, the government is saying you're a terrorist without any whatever evidence. Like bol diya bas, and you have to prove that you're not.
There's a media report. Scroll did an investigation on the charge sheets that Delhi police has filed in
Yes.
in the larger conspiracy case, and they tracked down 2 of these protected witnesses, and they went and asked them, "आपने ऐसा statement दिया क्या पुलिस को?" And the protected witnesses are saying, हाँ जी हमें तो प्रेशराइज किया, हमें तो कोर्स किया, इसलिए हम लोगों ने ऐसा स्टेटमेंट दिया. Now if they would have said the same thing before a trial judge, the case would have
Yeah, it would have just
crumbled.
gone. Yeah.
Yeah.
See, that is another reason why I think they don't want it to go to trial because the process becomes the punishment now.
Exactly.
Is as good as they are in jail now. Plus, unka lawyer पे पैसा लग रहा है.
And the high court judges know this very well. Coercion of witnesses and these prosecution witnesses, कैसे witnesses को लाते, they know this very well. They see this day in and day out. So therefore, it's a dishonest judgment because Shailendra Kaur, who authored that judgment, and Naveen Chawla was the other judge who agreed with that judgment. They knew कि once this matter goes to trial, it's going to crumble, and therefore there's a prolonged incarceration. We can exercise our discretion and give them bail, but they didn't choose to exercise that discretion. So it's dishonesty.
No, absolutely.